All right. So um, the whole of this week we're dealing with the law reform process. It's a technical area of legislative drafting. The reason is after you do your reform exercise, you need to produce a bill which will be submitted to either the State House of Assembly or the National Assembly. So that requires knowledge of the process. Knowledge is a very technical knowledge. There was a project in the year 2011 by Ligapedia, a company for Oyo State. They charged Oyo State 69 million naira. That's almost like, let's just say, $6 million to revise the laws of Oyo State. That's to tell you how lucrative this area of law is. You can do it as a government staff or you can do it as a consultant for governments. Governments are always in need for the laws to be in tidy form. When the laws are not in a tidy form, it's difficult. Lawyers who go to court, you cannot cite, you don't know the law to cite. So it's good to have your statute books in a good condition. So that's the whole essence of this law reform process. So we said there are three words. Law review. Law review is a preliminary step when you are scoping, you're looking to identify what you need to do, whether you need to do law reform or law revision. Law revision happens every 5 years. Law reform happens every 10 years. The difference between law revision and law reform is that law reform needs to end up in front of the legislature. The legislature would pass a law to give effect to the product of the law reform process. However, the law revision does not require going to the legislature because no substance of the law has been touched. So you should know these two differences. Law revision means putting the books in order, tidying up, formatting, doing an index of the laws. You do not touch the substance of the law, but law reform requires touching the substance of the law. And once you touch the substance of the law, even if you change, you put a comma, you put a full stop, once you have touched the substance of that law, then you need the legislature to give approval to it. So these are the fundamental differences. Then we said there are other words like codification, consolidation, indexing, gazetting. These are all technical words that need to, as a lawyer in legislative drafting, you need to have a grasp of these things. When they say a document has been gazetted, what does it mean? You need to know. There's an area of law we did not even talk about. The procedure for treaties. You know, treaties are international laws that your country is obligated to obey. Now, the procedure for treaties in Nigeria, I don't know about your country, but in Nigeria, I'm going to type, we have a law that governs treaties. You don't just pick up any treaty and say it's enforceable in Nigeria. There's a law, the Constitution of Nigeria, Section 10. Is it 10? No, Section 12 is about treaties. So there's another law called Treaties Making Procedure Act 1993. This is a law that governs how treaties are dealt with. So the law says the Attorney General of Nigeria keeps a register of all the treaties because the treaty process is also different. Because after you've signed the treaty in the international body, maybe the United Nations, in Nigeria, you need to bring it. The National Assembly has to pass a law to make give effect to that treaty in Nigeria. So even if you have ratified it at the UN, it doesn't automatically become part of Nigerian law. You have to come back, submit it to the National Assembly, then it will be enacted as a law. So what this teaches us is that there's a process. There's a register in Nigeria, there's a register kept by the Attorney General of all the treaties that Nigeria has domesticated. Domesticate is a word that means you have brought it to your national law. It's now part of your national law. If you sign it, signing it, ratifying it alone at the UN doesn't make it part of your national law. You have to domesticate it. I don't know the process in Lesotho, whether you have to also pass another law for an international treaty to become part of your law. So please, can anyone tell us what is the procedure in Lesotho for making a law to be an international law to become part of your law? Yes, Tumelo, please go ahead. Yes.
Yes, thank you very much, Prof. I think the first step that normally happens is that the Minister of Foreign Affairs has to sign the treaty itself at the international level. And once it has been signed, the minister will consult with the relevant departments within the Ministry of Foreign Affairs and related ministries to come up with a national legislation that will be presented to the National Assembly. And once the drafted law has actually been passed through the ordinary process of the National Assembly, then it is then taken that we have domesticated the particular treaty. So generally, I believe it has the same process as the Nigerian process. Thank you very much, Prof.
Okay, thank you. Now, another question is, in Nigeria, the Attorney General is the one charged with keeping a copy of all the treaties. In Lesotho, what's the procedure?
Thank you very much, Prof. I think what generally happens is that the relevant ministry that spearhead the engagement at the international level will still have a copy, but because whatever domestication happens would be put in line with the National Assembly, then it would still be the National Assembly staff that has also a copy of the domesticated law, but the Ministry of Foreign Affairs is the actual custodian who can also share with the Attorney General for being the head of legalities of government. So it would be those two offices that are charged with that correspondence, unless the colleagues will add. Thank you.
Yeah, you have answered, but we need to look at, can you look at your constitution? Let's know.
Good afternoon, Prof.
Yes, listen,
Yes, yes, sir.
go ahead. What is the constitutional provision?
I'm sorry, Prof. I just came into the office now, rushed in. I did not even get the question. I just joined just now.
Okay. Well, no, we are discussing the procedure for treaties. In the chat box, I've written Nigeria has a law called Treaties Making Procedure Act. That is a law that governs how treaties are. It even gives you a classification of treaties. Now, that law says that the Attorney General shall be the custodian of all treaties, the register of treaties of Nigeria. The reason is, even if you sign a treaty at the international level, if you ratify, it doesn't automatically mean that that treaty is part of Nigerian law. The National Assembly still has to enact a law to give
Yes.
effect Yes, that's the procedure. Section 12 of our constitution. So now,
Okay.
I'm now asking, what is the procedure?
In Lesotho.
Yes, in Lesotho.
Well, the procedure is quite the same. I just can't refer to a specific section of the Constitution, but ratification does not automatically qualify a law to operate. It still has to be domesticated. There still has to be enactment of that law for it to be enforced. I just can't quite recall the provision in the Constitution.
Okay, don't worry. Let's hear from Tumelo. You were raising your hand.
Yes, thank you very much, Prof. I think the section we are looking for is section 146 of the Constitution
Mhm.
that specifically states that all international affairs of the country shall be dealt by the Ministry of Foreign Affairs by advice of the Prime Minister to the King that a particular officer of the ministry should be responsible. So in terms of foreign treaties and all those instruments, generally the constitution identifies the minister responsible for foreign affairs. I believe he still has to work in conjunction with his attorney general, of course, but it's 146.
Okay, 146. That's good. Nigerian Constitution is section 12. Yesterday, I shared a copy of the latest Nigerian Constitution with the 5 alterations to the Constitution. So today, let's talk about so we've dealt with the international law, treaties, how treaties are dealt with in your country and in Nigeria. Now, let's deal with the Constitution. Now, the copy of the Constitution I shared is the latest version because it has the 5 alterations to the Nigerian Constitution. Alteration means since 1999, Nigeria returned from military rule. So since then, that's when we got our 1999 Constitution. So from 1999 till date, there has been 5 alterations. We call them alterations. So each of those 5, they are attached to the Constitution. Now, I know that Lesotho tried to amend their constitution or alter their constitution in the year 2021, but it never happened because of so many reasons. There are provisions in the Lesotho constitution that require amendment by alteration by referendum. Some require simple majority, then some require 2/3 majority. It's the same in Nigeria. Like Ebenezer told you yesterday, some provisions to alter the chapter 4 of the Nigerian constitution that deals with fundamental human rights, you require 4/5, not 2/3, 4/5 approval. So that is higher than 2/3. So these are all things that you need to know about the alteration of the constitution. It's a very cumbersome process. And the reason is the constitution of any country should not be easily amended like the process for other laws. Because if you make it easily amendable or amenable, that means people with bad intentions can change it to suit themselves. As I speak to you today or yesterday, Nigeria has a situation, it's as if we're going back to military rule. The president declared a state of emergency in a state of Nigeria, ordered a former military to become the sole administrator. So people are screaming that yes, there's a provision in the constitution, section 305, for declaration of state of emergency. However, the conditions in that section are so stringent, and the drafters of the constitution made it so stringent so that Nobody with bad intention can use that. And that is to prevent that. That is why we made the constitution so strict for the conditions to be fulfilled before declaration of state of emergency. For example, you have to get the resolution of the National Assembly, the Senate, and the House of Reps. They must vote to support the president. Now, apart from that, there are the conditions before you declare a state of emergency. There must be an act of war or threat, imminent threat of war. It's not because the president feels like, he has to show the evidence that this has occurred. So we in Nigeria, we are worried that these things have not occurred, that the president is trying to use this as an excuse because the political party ruling that state is not the same party as the president. So they want to use this state of emergency as a ruse, a trick to take over that state. That's what. So the Nigerian Bar Association, the Nigerian lawyers, they have come up to say, no, we do not believe the conditions. Today, the National Assembly is supposed to vote whether they support the president or not. So you can see in the drafting of the Constitution, the provisions are made very stringent so that people do not abuse those. You remember what happened in Lesotho? The former prime minister, after parliament had been dissolved, they reconvened parliament. They declared a state of emergency so they could reconvene parliament and pass the omnibus, those bills they could not pass to alter the constitution. Your constitutional court ruled that that was unconstitutional. Once parliament is dissolved, you cannot use the state of emergency to bring back parliament. These rules are put there, made in the constitution, so that the constitution cannot easily be manipulated, because politicians are the most manipulative people you can come across. So the purpose of the laws, the way the constitution is drafted, is to minimize the ability of politicians to manipulate the constitutions for their personal purpose. So you need to know that as a legislative drafting lawyer, that these processes have to be followed when you're doing the law reform. This is for those in law reform commissions, whether in Nigeria, anywhere in the world. If you're advising the government, you must make sure that they follow the steps in the constitution alteration process. If you fail to follow one step, you have nullified every other thing you have done. So please, if you have questions, in your country, you call it PITSOs. PITSOs, public hearings are a mandatory requirement. If somebody does not, if you amend the law without subjecting it to public hearing, if that law is challenged in court, it can be thrown off, because in our constitution, section 60 is the provision of the constitution that under which public hearings are made a mandatory part of the legislative process, of the law reform process. So if you are a law reform agency and you reform a law, you sit in your office, okay, this law needs reform, you draft the reform bill, you send it to the parliament, they pass it. And if any human rights activist goes to court and says one of the requirements was not met, which is you did not conduct a public hearing, PITSO, as you call it in Lesotho, that law can be declared null and void. So, any questions? Any questions? Any questions? Any questions? the skills, the knowledge we are gathering from this are specialized knowledge. It's not every lawyer that knows that they can do this. Any questions? Any questions? I have been, because of what is happening in Nigeria, this day newspaper, their legal editor has asked me to write about what is happening in Nigeria. I've been receiving several calls because of it. So I need to be responding. Yes, Madam Anino.
Hello there.
Yes,
Good afternoon, sir. Good afternoon, everyone. Sir,
yes.
please, I would like some clarification as to you said for fifth approval of whom I am for the Nigerian alteration. I missed that part out, sir.
For
You said to effect an alteration in the Nigerian constitution, we required for fifth approval of.
that's if you're altering the chapter 4, fundamental human rights.
Okay.
The,
Okay, and
the
okay.
reason is that fundamental rights are very important. Therefore, they should not easily be, because some unscrupulous politicians want to suspend it and say, let's bring in military rule.
Okay, so
So
that's for fifth approval of the Senate.
both the
Hmm?
National Assembly and the 36 states houses
Okay,
of assembly.
okay,
For fifth is higher than, for other alterations, you need two-thirds, which is 25 states. But for fifth means you are looking uh, at least 30 states. But
okay,
for other amendments, alteration of the constitution, you only require 25 states. But for alteration of the human fundamental rights, you now require more.
okay. Yes, sir. Thank you, sir. And then there's one more I would like to clarify. You said section 300 and of the Constitution. I didn't get that. Made provisions for the declaration of a state of emergency.
305.
Okay. Thank you very much, sir.
305.
Okay.
Any other questions? Any other questions?
Hello, Prof.
Yes, Tegohu.
Just out of curiosity,
Mhm.
particularly my colleagues in Lesotho, I understand there is a law on the bill that is being made now. I think it's a private member bill, if I am correct. They are making public consultations now. So I have been eagerly waiting for the schedule to see where the pizzas are going to be held so that I may attend if I just want to get the philosophy behind making an act on the bail. I don't know if Mr. Lesenyeho or any of my colleagues would know of the schedule for the pizzas with regard to the bail bill.
You should know that. Then let me give you a background to PITSOS. PITSOS became a mandatory requirement In the UK, it became mandatory in the year 1998. In the year 1998, the UK joined the European Union. Before then, you know, the UK, they are proud. That's why till today, even when they joined the European Union, they refuse to change their currency. They still use the pound, British pound sterling, which is the strongest currency in the world. They are proud of their money. They refuse to use the euros, which is for the currency for the whole Europe. Now, as part of the requirements of joining the EU, it was made mandatory that public hearing, which is PITOs, should be held. Before then, Parliament in the UK does not need public hearing. They just pass their laws. But those PITOs became a requirement of European law. So when UK joined the EU, that requirement became part of their laws. It was passed in the year 2008. They have what they call Legislative and Regulatory Reforms Act. They had to reform their legislative system because they have now joined the EU, which legal system is a bit different from the United Kingdom. The United Kingdom and Ireland, Republic of Ireland, are the only common law countries in the whole of Europe. They are surrounded by civil law jurisdictions. So when they joined the EU, which is predominantly civil law, their legal system, their legislative system had to change at least a bit. And one of the changes is this PITSO, public hearing, is mandatory by virtue of the Legislative and Regulatory Reforms Act. You cannot pass a law that will affect people without consulting those people to say, what do you think about this law? That's the idea behind PITSOs or public hearing. So in Nigeria too, the idea was in 1999 in our constitution, they put section 60. It does not say directly that you should hold PITSO, but it gave the power to the legislatures to make their own standing orders. So under those section 60, they now made the requirement that they would do what's it called, PITSO, as part of the lawmaking process. I think it's first reading, second reading, third reading, committee stage. That's where you do public hearings in Nigeria. So any questions? Any questions? Yes, Madam Anino.
Yes, sir. I'm sorry, Prof, to be bothering you, but I wanted to be clear on certain terminologies that I have an understanding of them. We had talked about ratification and domestication, and you said that to ratify meant that we had signed on to a treaty. Now I want to know who signs a treaty. I don't seem to have a mental picture. Who signs it?
Okay, so treaties are signed by the minister in charge of that. If it's an agricultural treaty, then the Minister of Agriculture will sign. If it is
Okay.
a science treaty, then the Minister of Science will sign. Then, after you sign, according to the Treaty Making Procedure Act 1993, the minister should bring a copy of the treaty back to Nigeria, give it to the Minister of Justice, which is the Attorney General of the Federation. He will now submit it to the Federal Executive Council. They will approve it that, okay, Nigeria has ratified this treaty. Now, Section 12 says, before you can now enforce it in Nigeria, National Assembly should pass it as a law. So the president will.
So it becomes domesticated, sir. Sorry. Is it
Yes.
at that point we now say it is domesticated?
Yes. So the president will write a cover letter send the treaty to the National Assembly for enactment. That enactment, when it has been enacted as part of Nigerian laws, that's when you say it has been domesticated.
Okay. Thank you, sir.
Mm.
Thank you. So one final question. I won't ask any question again because I seem to be monopolizing the floor today. So it means that it would be couched when we are wanting to domesticate. Do we now have a bill, and does it read a law for a bill to domesticate? Is that how it is done?
Go online as we speak. Just
Yeah.
pause and look at there's a law called African Charter on Persons and Human and Persons Rights. Go and look
African
at it.
Charter.
That's a
Okay.
classic example of how
On
a
human.
treaty is domesticated into Nigeria. It's a very
Yes,
short
sir.
law, one
Okay,
page,
sir. You said African Charter on Human and
people's rights. Just
okay,
one
sorry.
page.
All right, sir. Thank you.
Yes.
Prof,
Yes. Go ahead.
before we part, do you know where perhaps we could get your books on legislative drafting? That's number one.
Okay.
Number two is, would you ever be interested in writing a book on legislative drafting concerning our jurisdiction, Lesotho?
Interestingly, do you know that I have a student that just wrote, in fact, she's a master's in legislative drafting student. Do you
Yes.
know the external examiner, a professor of law, said she compared the amendment of constitution in Lesotho and Nigeria? Ordinarily, master's dissertation is just 100 pages. This girl wrote 250. They said it's a PhD work. She has well documented. Well, so I will share with you. Let me give you my WhatsApp number. If you contact me on WhatsApp, I will share with you. If you can add any, I told her, look, this is not the kind of work you just score an A and go. I need you to publish this thing. If I look for a lawyer in Lesotho who is interested, he can add more to it, and then you can publish as a book because it's so well written. Let me give you the background of this student. She works at the Supreme Court of Nigeria as a research staff for the judges. She has been there so many years. So because of that, her writing skill is so, in fact, she writes judgments for those judges. So her research and writing skills are so high. You know, for you to write a judgment of the Supreme Court, you need to research to know the current state of the law. So she's used to research.
Yes.
So yes, I've put my WhatsApp there. Reach me on WhatsApp. I will give you. I have some copies of my books here. Then I can give you the soft copy. I don't have. I have two hard copies of some of the books, but the others I have them as soft copies, so I can give you. In fact, we created an e-library of legislative books. There's a legislative law report. There's a legislative law journal. There's a drafting, all the books on drafting, the soft copy. So we have it.
Yes.
We can give you access to this thing. So we can give you access to that. There's some part of it is free, but some part of it, if you want more, they will say you make some payments.
That's fine. I mean, I wouldn't expect anything less.
Thank you, sir.
Hello, sir.
Yes.
Thank you, sir.
Sorry.
Yeah.
Good afternoon, sir. want to partake in that benevolence too, are we free to reach out to you?
Yes, yes,
Okay, sir. Thank you, sir.
yes. We're something we're even doing for, or we plan to do for Zamfara, to digitize all their laws from when Zamfara was established. That is 1996. We put them in a digital format so that their lawyers can reach them, because hard copies, people are not, they are complaining. For Zamfara, some of the laws, they rely on laws of the mother states, which is Sokoto, when they were created. And sometimes you cannot find copies of that law. So we want to digitize them so that lawyers can have access to them. So I'm going to even put, there's a website where you can see our lodge. Oh, okay, I'll put it on our platform.
We eagerly await that, sir.
Yes. Yes. Remind your AG. I thought he had gone back so that we would go and meet him.
Okay, sir. He's still in Abuja, sir.
Ah, okay.
Yes, sir.
He said he even wants us to extend to the State House of Assembly.
So true, sir.
So let's see when he's back home. We come
Okay,
and
Prof.
for you guys.
Okay, Prof. Thank you so much. See you soon.
No problem. I hope when I served in Sokoto State for my NYC, so we used to those days you drive from Abuja, you must stop
Yes.
at Kalata Mafra and eat.
Yes.
But I enjoy the suya in Talata Mafra. It's one of the best I ever. So anytime I look forward to, we have to stop at Talata there.
Okay. We have great suya all over.
So I look forward to that.
We await your comment, sir.
Well done.
Thank you, sir.
All right. Any other questions? Questions. So on our platform, I'm going to post. There's a journal called the International Journal of Legislative Drafting and Law Reform. It started publication in the year 2012. So we have I think 12 or 13 editions. It's been published by the Canadian Institute for Legal Information. So I'm going to share with you the link so that you can go there and it's free. You can download it. The good thing about that article is you will see articles on legislative drafting from every country. Saudi Arabia, the style of drafting under Islamic law is there. The enacting formula in what's it called, in Islamic states is not the way you draft in other countries. So a lawyer whom I studied with at the University of London, he did that article, very well written. So apart from that, you see different areas of law, how to draft technology laws, they are there. So take time to look at these things. The good thing with internet, you have a phone. You could be in a meeting or you could be waiting for somebody. You could open up that website and be reading. So I've just posted it on our group chat.
Thank you, sir.
Sometimes when you get something free, you may not know. This journal, each of it is $100. So 100 times 14 editions, that's $1,400. So you are getting it for free.
We truly appreciate this benevolence, sir.
Thank you so much, sir.
Thank God. So yes, any other questions? Any questions? You know, in the reason I've been on the phone since this thing happened, I've been receiving calls from everywhere. Nigeria has over 200,000 lawyers, qualified lawyers. Why do people reach out to me? I'm not even in Nigeria at present. Even the governor of Rivers State, he has a legal team. He has an attorney general who is a senior advocate of Nigeria. But when it comes to areas of legislative law, because I've invested my study, my scholarship, my practice in that area, that is why, and that's the point we're making is the purpose of this study is to elevate you from mechanic to automobile engineer. I still remember there are many things. I did a master's in legislative drafting. But when I joined this PhD class, the first lectures we were having, this is when I was introduced to most of these concepts. I never heard about them. Public hearing, PITSU, as part of the legislative process. I never knew that this was a requirement. Okay. Yeah. I never knew until my lecturers, they were introducing me to all these concepts in legislative drafting, in constitutional law. So that's the benefit of formal education. In addition, you combine formal education with your on-the-job training. What you learn from the job, yes, is there. That is one hand. Then what you gain from formal education, when you combine the two, you become a better legislative drafting lawyer. So, for example, when the president did this thing, the president is advised by an attorney general who is a senior advocate of Nigeria. The chief of staff to the president is a lawyer who was a former speaker. But they do not know some of these procedural things that are drafted. Why are these things put in the constitution? The reason is to prevent tyranny, dictatorship by one man. That's why they say, no, you must get a resolution of the National Assembly. Because they know that the president is one man. He can make a decision. But for him to get that decision, to win the National Assembly, 2/3, our National Assembly is 469 persons, legislators. So it takes a lot of effort to get 2/3 of them. And the reason is so that there will not be tyranny where one man can just make a decision and then he can get a certain number of legislators. If it was simple majority, 1/3, he can use bribe to get 1/3. But when the constitution says 2/3, it becomes more difficult. So these are the reasons why these things are put there. So as a drafter, you need to look at what the constitution says, how it is drafted. These conditions are conditions precedent before you declare a state of emergency. Let me share with you, when your attorney general asked me, I still remember 2021, I wrote a legal opinion to him. I said, it has happened in Nigeria before. Parliament ended on, let's say, 19th of March. But because they didn't finish some bills, they sat again on 20th, bills on 20th. The Supreme Court of Nigeria said, no, you have ended officially. That's why in the Constitution, at the beginning of Parliament, there's something called proclamation. There must be a proclamation. A proclamation is not just by words. There's a document the president needs to send to say, I hereby proclaim the beginning of the assembly. At the end of the assembly, there's another proclamation. So once those constitutional requirements are made, a proclamation is made. You cannot transact business after the proclamation. So I use that to advise, even in Kenya, there's a Kenya case law by the Supreme Court. I sent it to your Attorney General to say, No, Parliament cannot reconvene after there has been a proclamation, no matter the emergency. So to use a state of emergency, your constitutional court said it was a self-induced state of emergency. And if you read that judgment, the constitutional court said you cannot just generate these things. It must be a natural happening event before you declare a state of emergency. The Nigerian situation is almost like that. The president is the one engineering the condition precedents are set out there. It has not been met. You just cook it up that, oh, and you now declare. So the drafters of the Constitution had an intention why they put those things to prevent tyranny, dictatorship. And that is what is happening. Because when you're drafting laws, you should draft laws with the mind that humans have a tendency to abuse power. So your drafting should be to prevent or minimize the tendency to abuse discretion, abuse power. So when you grant a power, then you complement it with safeguards against abuse of power and discretion. Even when you confer discretion, there must be safeguards. So section 1, sub 1, you have conferred a power, a right. Then conditions, subsection 2, the conditions to enjoy that right, to enjoy that power. There must be conditions. Otherwise, you create an absolute tyrant who does not answer to anybody. And that's not the purpose of democracy. Okay, any questions? Any question? Any questions? Any questions? Okay, so tomorrow we continue with the law reform process. Is a long process. There are many activities under that process. We keep repeating them so that you get familiar with them. So on that note, if there's no further question, we can call it a day. All right.
Thank you very much, sir.
Thank you for your time. Thank you, Prof. Thank you for your time.
Thank you, sir.